Good morning, Mr. Martin. Can you hear me? You're muted. Now calling case number 23S00425. This is the State of Michigan versus Eric Martin. Can I have appearances for the record, please?
Stephanie Cannon with the Washtenaw Public Defender's Office with and on behalf of Mr. Martin, who is present, Your Honor.
Okay. Thank you. Mr. Martin, can you please state your name for the record?
Capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N.
Okay, thank you, sir. Today is the date and time set for an arraignment in this matter. What I am seeing is that you failed to appear for a court date on February 1st, and that you failed to appear for another court date on March 14th. Therefore, a bench warrant did issue for your arrest. Do you understand?
No, I do not understand, and I do not stand under the charges. I am one of the sovereign living people.
Okay, sir, I'm not asking you if you agree with me. I am asking if you understand the words that I just said to you.
Well, I do not understand. I might comprehend that I do not understand and that I do not stand under the charges. And I am not a defendant. I am a living human sovereign. I'm not the legal fiction corporate entity, all capital letter name.
Attorney,
I do not accept an attorney.
Thank you, Your Honor. At this time, he would stay on mute and ask for a PR bond.
Objection. You're not speaking for me. You think you're my attorney.
Thank you for the attempt, Attorney Cannon. You can turn your camera off.
Thank you, Your Honor.
Okay, Mr. Martin. At this time, I am seeing that your license has been revoked. You have failed to appear for court dates in front of Judge Washington. You were to have a sentencing hearing and a pre-trial date in front of her, so that is what I am going to set you for now.
I need you to repeat to me again the case number of this case. I couldn't get it all when you said it first time.
The case number is 23S00425.
23S00
4.
Hold on. 23S00, right?
Correct.
Okay, after that, what else?
4.
Okay.
2.
Yeah.
5.
Was that it?
Yes.
Yes, 00425. All right. That wasn't finished. Cut me off. Okay. I had more to say.
Sir, I am setting you for another. Yes, I am. Because what I am doing today is arraigning you, and I am setting you for another court date in front of Judge Washington. That court date will be April 11th, 2024. That will be at 9 a.m. That will be for your pretrial and potentially your sentencing.
I can't remember all this at once.
April.
Yep.
11th.
Yep.
9 a.m.
All right.
That is 9 in the morning.
Okay. Got that. What else?
It will be over Zoom, like this hearing.
Right. Okay, now. Okay, is that it for that? Okay, now. Let me ask, so does she call herself? Is this a separate charge?
I'm not entirely sure what you're asking. So what happened here was that a bench warrant was issued for your failure to appear. At this time, to guarantee your appearance at the court date on April 11th at 9 a.m., that warrant will continue.
Okay, that wasn't intentional, so that's why it's baseless. It's baseless, and it shouldn't have been a warrant issue because.
Okay, Sir, you've got your next court date. That's April 11th at 9 a.m. The bench warrant is continued. This hearing is concluded, and you are free to sign out of Zoom.
So I have more to say. I'm not done saying what I have to say. Pursuant to my First Amendment right, I have more to say here. That is,
And once again, this moment shows exactly how quickly a situation can unravel when someone refuses to engage with the court in the way it requires. What should have been a straightforward arraignment turned into confusion, interruptions, and a complete disconnect between what the court was asking and what the defendant was trying to argue. The judge wasn't asking for agreement, opinions, or theories, just a simple confirmation of understanding. But instead of answering directly, the defendant shifted into arguments about sovereignty, legal identity, and refusing the label of defendant. That's where things begin to break down, because in a courtroom, words have specific meanings and questions are asked for a reason. When a judge asks, "Do you understand?" they are not asking whether you agree with the charges. They are asking if you comprehend what is happening procedurally. That distinction matters. And when someone avoids that distinction, it doesn't strengthen their position. It weakens it. Another key moment here is the issue of failure to appear. Missing court dates is not a minor detail. It's one of the fastest ways to escalate a case. That's why a bench warrant was issued, not as punishment for an argument, but as a response to not showing up when required. And even at this stage, the court gave another opportunity, setting a new date, explaining the next steps, and simply asking the defendant to follow through. But instead of focusing on that opportunity, the defendant continued to argue, interrupt, and insist on being heard on points that the court was not addressing at that moment. And that leads to another important reality. Timing matters. There is a right time to raise arguments, file motions, and challenge the case, but it has to be done within the structure of the process. Even the attempt to involve the attorney became another point of resistance. The court provided legal representation, which is a fundamental right, yet it was rejected while at the same time objecting to the attorney speaking. That contradiction only adds to the confusion and makes it harder for the case to move forward in any productive way. In the end, the judge did exactly what the process requires: set the next court date, maintain the warrant to ensure appearance, and close the hearing. Not because the defendant wasn't allowed to speak, but because the purpose of that hearing had been completed. So the real takeaway here is simple. The courtroom is not a place where speaking more gives you more control. It's a place where understanding the process gives you leverage. Without that understanding, every attempt to push back can end up doing the opposite, pushing the situation further out of your control.